My name is Ryan Nelson. I am an employment law defense attorney and an HR professional. I'm responsible for the Utah Office of Employers Counsel. Employers Counsel is, well, we're kind of like mechanics for employers in the areas of employment law and HR. We can do tune-ups, overhauls, repairs, we can build it, we can tear it down. It just depends on what an organization needs. But we provide services on a membership basis rather than an hourly basis. It's just the model that we've used now for almost 80 years, and I think it works very well. Having come from a law firm, I very much enjoy not having a billable hour in the relationship when I'm working with our companies. So what we're going to cover today, we have about an hour and a half, well, a little less than an hour and a half, and in presentations that I do, there's nothing off limits. So if in the content we cover that I've planned to cover isn't meeting a question that you have, don't hesitate to ask. I'll try and work it in and perhaps we'll just address it. But what I've found in my time in this capacity is there is a lot of low-hanging fruit that employers just don't know about. Or there's misinformation about the what or the how or the why we do something. So I've put this presentation together with that in mind, to identify some of the key and, from my perspective, easier issues to manage that, again, often most employers just don't think about or they're not aware of because this isn't what you guys do. It's kind of like me trying to install an HVAC or a plumbing project in my house, and I can read a book about it. I can Google it, I can watch a YouTube video, but there's a difference between the product that I would most likely create as compared with what you guys would do, because this is your areas of expertise. Well, the same analogy holds true with HR and employment law. Now, again, I want to be very, very comfortable and clear that if you have questions, please feel free to ask, okay? And that goes with any of the presentations that I do today. So I like to begin with an analogy. Many of you perhaps have played chess. I like it, I enjoy it, but I think it presents a very interesting analogy for the type of relationship that exists between an employer and employees. Now, I don't mean to suggest that it's adversarial. That's not what I'm trying to identify here. But in chess, you're thinking many, many moves ahead to ultimately accomplish whatever your strategy is. Well, in a relationship with your employees, that's the same idea. Because when we look at the employment relationship from the perspective of the law, administrative law, such as the Equal Employment Opportunity Commission or the Utah Labor and Anti-Discrimination Division here within the state, there are certain requirements, certain expectations, certain burdens and responsibilities that you as a business must comply with, whether you knew that or not. And so when we talk about these issues today, what I want you to keep in mind is this comparison to a game of chess. Okay? The key is to understand what your final moves are or where you want those pieces to be, and then today begin to put those pieces in the places you need them so that you can successfully defend what may happen. Because, and let me hone in on this one point and then we'll move into the content. One of the key weaknesses that employers have is at any given point, an employee can make a claim. They can literally go to an administrative agency, whether it's here at the state or at a federal level, and they can fill out a piece of paper that says, I have a complaint against my employer. That piece of paper is given a presumption of correctness, at least initially, to open up a file or an investigation. And the burden then shifts to you, the employer, to demonstrate that you've complied completely with the law, that you've not screwed it up. Now, that's not typically what we think. In litigation, in trial, or in the criminal law, you are innocent until proven guilty. Well, in employment law and administrative claims, you're guilty until you can demonstrate that you didn't screw it up. So it's a little bit backwards there. But this analogy holds true because I want you to think long-term, how can we successfully defend the decision we are making or that we will make. And that begins again by putting the pieces in the right place. So the goal today is to help you see what that end game is in various areas of employment law and HR. We'll talk through as you have questions about how you can do that. But I must add one caveat. This conversation today is not legal advice. This is not attorney-client relationship or attorney-client privilege. This is just the gospel according to Ryan. And so if you do want legal advice or attorney-client privilege that attaches to that, you need to personally, in a more private setting, have a conversation with legal counsel, okay? Because this is not today. The privilege is waived because there's a room full of other individuals, and that's not how the attorney-client relationship works. All right, so with that in mind, keep this analogy as we walk through these various subjects, okay? Now, because the screen is so high, I'm going to shift around to the side a little just to make some points, and it hurts my neck to stare that high. All right, I-9s. How many of you have ever completed an I-9? How many of you have ever completed one for your employees? Okay. What did you think about the I-9? The process, the paperwork? Not bad, okay. What else? Have you ever read the instructions that come with the I-9? They're literally like 8 pages. There are 2 sections in an I-9 that are critical for an employer to focus on. And again, the burden is yours to make sure this is done correctly. It's not the employee's fault if they screw it up. If the I-9 is incorrect in various aspects, that's your problem. That's your business's liability and issue. If you have an audit and they find an incorrect I-9, that's your company's issue, not the employee's. Okay? So the key to focus on is who has to do it, and then what does it look like when we do it. So everyone hired after this date, November 6th, 1986, must have an I-9. If they are still your employee, you must still have that I-9 on file. Now, if they leave your employment, we'll talk about how long you have to keep those records for. But everyone, part-time, full-time, temporary, if they are an employee, even if they only work an hour, they must have an I-9 completed before they actually begin, or within a 3-day window of when they begin the working relationship with you, the employer, the business, the entity. Okay? So, what does it look like? You have, again, these 2 parts, Section 1, Section 2. Section 1 is completed by the employee, and there's a window of time in which that can happen. Pre-employment, you can actually, after you've selected the individual, made, and they've accepted the offer of employment, you can actually give them the I-9 to complete, or the Section 1 to complete at that point. But it has to be employee completed. You do not and cannot complete that section for the employee. If they make a mistake in it, it's up to them. You need to point it out. They need to be the ones who complete it or correct it. Now, Section 2 is your obligation. Now, ideally, you will have within your organization 1, maybe depending on the size, 2 individuals who will be the I-9 owners. They will own the process and the documentation piece. When you spread it out amongst various people, you run the risk of inconsistency, and inconsistency potentially leads to liability for you. So just make sure that you have designated individuals and that they're trained. So Section 2, then, we go to your part. After you've received the initial information back from the employee on this form, your obligation now is to verify identity of the individual and their right to work in the United States. And they do that by way of 2 types or 3 types of documents. You have List A, like a passport, which shows identity, picture, name, identifying information, but it also identifies my right to work in the United States by virtue of perhaps being a U.S. citizen. So List A documents suffice for both identity and right to work. Then there are List B and List C documents. List B and List C identify one of each. List B, I believe, identifies identity. List C is right to work. If they don't have a List A, They must have a List B and a List C document. Now here's the kicker. You cannot tell the employee which documents to choose. You cannot require that they bring in a birth certificate and a driver's license. All you can do is give them the list of acceptable List A or List B and List C documents and let them choose. They then present whatever documents they've decided to bring to you, and your job then, in completing Section 2, is to review that documentation, the identification that they've provided, to ensure, for example, that it's not expired. Like a driver's license that expired the previous year would not be a valid form of identification because it's expired. So you have to look for those things. You're also feeling it and looking to see, does it look authentic? Now, you're not experts and you're not expected to be experts in document fraud verification, but if I hand you a paper Utah driver's license, you should intuitively know that there might be an issue there. Utah doesn't issue paper driver's licenses. They are laminated. If the picture ID is on them, they have a formality to it with a barcode that can be scanned. There's identifying numbers. There's holographic images embedded in that document. You should know those things. Those are just because you all have one probably in your wallet. Okay? So you have to look for those things. Now, our recommendation is that you copy whatever documents they've provided and that you just keep those attached, paper clipped, not stapled to the I-9, just in case. It shows that you've done your work, your due diligence, and you have a paper trail to keep after the fact. All right. Now,
that can also be electronic too.
You can convert paper into an electronic format, but keep this in mind. If you do that, the I-9 requirements and how you store the documents, they have to be, actually let me back up. You should have an I-9 file for all current employees, and then you have those who are former employees but were still under the record-keeping time frames, which I'll talk about in a minute. And once you're outside of that, all the other ones should be destroyed. You shouldn't keep them past this time frame, which we'll talk about in a minute. Because if you do, and I audit, I'm entitled to see all of them. And if you have mistakes in I-9s that should have been destroyed but were not, I can still ding you as an auditor for that. Now, to Ralph's point, can we go electronic? Yes. Your electronic system needs to mirror a paper system. It needs to be locked down. They need to be just in an I-9 file. I would arrange them according to current employees and former employees by chronological order so that in an audit, the auditor can quickly thumb through and see exactly who's who and when they were hired and pull out one to look and verify that you've done it correctly. You also need to install certain firewalls. Now, the USCIS federal organization provides a lot of detail as to what those firewalls look like, how they have to be created to ensure that you're in compliance with your I-9 record-keeping requirements. But you can make them electronic, but it's more sophisticated than just scanning a PDF and dumping it into a file on your desktop. Yes?
You said paper clipped and not stapled?
Yes, auditors don't like staples because I can't separate the information, so paper clip them. It's grease for the skids, trust me on that one. Paper clip, don't staple.
So do you have to keep both?
You don't have to keep the documentation. We recommend that you do, but you have to keep the I-9, and that brings us to, well, for how long? So there's two time frames that you're looking at with the I-9, how long you keep these. First, for every current employee, you must have an I-9. If they are working, if they're on your payroll, again, however much they're working with you, doesn't matter. If they're on your payroll, you must have an I-9 for them. When you move to a separated or a former employee, you have two deadlines or dates or time frames to consider to determine how long you keep that I-9. And it's the longer of one of these two dates. So after the termination, you retain the I-9 for the longer of 3 years from the date of hire or 1 year after termination. So let me give you an example of what that looks like. I began work in 2011 and I quit January 1 of 2012. So I start January 1 of 2011 and I am terminated January 1, 2012. How long does the employer have to keep my I-9?
2 years.
3 years from what? Okay, so 3 years from the date of hire would be, I started again January 1, 2011, so 2012, 2013, 2014, that would be 3 years, or 2 years after my termination date. Does it meet the 1 year after termination requirement also? It does. So that's the longer of the two dates that you would choose. Each time you need to make that analysis, which is the longer of these two dates, 1 year after termination or 3 years after hire. So every employee who's terminated and you're preparing to destroy that I-9, that's the question you ask. All right. Questions on the record-keeping component?
So if you got a guy that works 5 years, he quits at the end of 5 years, you only have to keep it for 1 year.
Correct. Did you hear that? If we have a man who, or someone who's worked, and again, I'll use my deadlines or time frames, January 1, 2011, works 5 years, January 1, 2016, quits. How long do I keep the I-9 in that instance? 1 year. Because we've already met 3 years from the date of hire, so now I'm just looking at the 1 year after termination. We good on that one? Yes.
This kind of goes back to a previous bullet, a requirement to do it within 3 days.
Correct.
Can we talk about that a little bit?
Absolutely.
So now we have employees that are still employed. We weren't here when they started. Can we still do, should we still do that?
Great question. All right, now this is one of those examples where I can't give you the legal advice to specifically guide and direct you. I'm going to speak in generalities, okay? So this requirement that you complete Section 2 within 3 days of the employee's first day. Now, first day, typically we'll think about and look at that as when they actually are performing hours worked in some capacity for you. That could be training, that could be actually on the job, but any time that they are owed hours worked, the clock starts, okay? And you have 3 complete business days to fill out your portion or part 2 of the I-9. Now, to his question, what if we just decide to audit some of our I-9s for existing employees and we discover, oops, we didn't do that, or we didn't complete the I-9, or we don't even have it? What can you do in those instances? Now, the answer largely depends on what's missing or what's happened, but generally there are some standards you just cannot do. For example, if you discover in an I-9 that they didn't complete or we didn't complete Section 2, or it was improperly completed, or we didn't find documentation, you can't backdate it and correct it. In other words, if I started January 1 of 2011 and it's March 28th, 2019, and you discover today that my I-9 is deficient, you cannot go back and correct it and backdate it. All you can do is note, and I would do something like this, a sticky note on the I-9 in an audit on March 28th, 2019, discovered that this I-9 was deficient. Here's what we did today to correct it. So we asked for whatever was missing, and you document it as of that day. Now, technically, you are deficient, but if you've never been audited before and you show good faith efforts to correct these types of mistakes, sometimes the auditor will just slap you on the hands and you now become on the list for a re-audit down the road, but you don't necessarily trigger fines and violations at that point. It just depends on the auditor. So if you do find mistakes, correct them and make them dated as of the date of correction. Do not backdate them. That would be illegal. That's fraud. Does that help answer your question?
Yes.
Okay. Excellent. All right. Situation number 2. This often comes up because we think about independent contractors quite loosely. We think about them based on the label rather than the work that they actually perform. So I want you to think, do we or do we not have independent contractors in our line of business? And if you do, what I'm saying is that you may or may not have an issue there. This comes up all the time because the misunderstanding with this concept is I, the employer, can unilaterally label an individual as an independent contractor. In other words, the label controls the relationship. And that is an incorrect understanding of how the employee versus independent contractor relationship works. An independent contractor, I always use this example, it's the plumber example. This is an independent contractor, and we'll compare it to an employee. Okay? So I have a leaky faucet, or I literally have a frozen cartridge in my shower handle. It won't open. So I'm going to call a plumber. How do I find the plumber? I Google it. I go to Yelp. I know someone because he or she advertises, or I have a neighbor down the street who I know is a plumber. So I reach out to that individual. He or she has all the tools. They have the training. They have the insurance. They are a business. And I tell them, hey, I need you to come. They show up when they can, at the time that they can. I point him to the shower. He brings his tools, his techniques, his information. He changes out the cartridge, reassembles it, hands me an invoice, and we may never talk again. That is an independent contractor. Now, contrast that with an employee. An employee is someone who we pay to accomplish tasks at our direction, on our timing, on our discretion, with our resources. What often happens is we label an individual an independent contractor because it saves us a lot of money right off the top. You don't pay taxes, you don't pay workers' comp, you don't pay unemployment, you're not paying overtime. And there's a significant savings there if indeed that individual is an independent contractor. The problem is your label does not control the outcome. If I look at this situation as an auditor, let's say I'm a wage and hour auditor from the Department of Labor, Wage and Hour Division. I'm going to look at the relationship. I'm going to look at the characteristics of the relationship, such as, and again, think of the plumber, advertising, business, insurance, tools, resources, training. That individual has all of those things. And the only thing I do as the customer, let him in the door, point him to the direction of the work to be accomplished, and pay him as he leaves. That's it. That's an independent contractor. Now, you have a variety of different state agencies and federal agencies that look at this issue. Within the state, you have wage and hour, and you also have unemployment. You also have workers' comp. On a federal level, you have the IRS, and you also have the Wage and Hour Division of the Department of Labor. Each of these entities has their own test to determine, do we or do we not have an independent contractor relationship, or is this indeed an employee that has been misclassified? The tests all focus on about the same thing. The question centers around, again, who's in charge? Who's in control? Is this individual indeed independent, or are they taking direction and control from the employer? Is there a financial control between the individual and the employer? Or is there a behavioral control between the employer and the worker? Here's another example. So I worked in a law firm, and then with the downturn in 2008, 9, and 10, a lot of the work that we did started to trickle off. We did a lot of contract reviews and real estate, and people just weren't buying stuff, and people weren't entering into deals with each other, so I was laid off. Now, I picked up a job with another firm, doing research and stuff on the side. Now, I had enough sense on my own to incorporate, because I wanted some corporate protections. But tell me what you think about the situation. This is actually what happened. So I had my own resources. I had my own research, or my own computer. I did some of my work at home, but the firm also gave me a space at their office where I could plug into their network, use their internet, use their resources, but I was an independent contractor. So what would you consider some of the issues in that situation? Was I or was I not? What do you think?
You were an employee.
Why?
You were using their resources instead of your own. You're using their internet and their office
Okay. Okay. Now, her comment was I was using internet, their resources, their computers when I was in their office. And those are indicators of an employer-employee relationship. Now, is that conclusive? Maybe. When we look at the independent contractor versus employee situation, think of a sliding scale. You remember those old scales that you step on and you move the weights back and forth? That's kind of the visual that I want you to think about. What we're looking for, you have employee on one side, independent contractor on the other. Each of these factors will move that weight one way or the other. Now, if you're in the middle, that's not a good, comfortable spot to be because there's a lot of risk. It's not clear what this relationship is. And if the investigator or the auditor feels that it looks like an employee relationship, then it's an employee relationship. And here's what happens in that instance. You are now responsible for back taxes, IRS, federal and state. You now have potential liability for unemployment taxes for that individual. You have potential liability for back wages, mostly in the context of overtime. So in my example, I worked some weeks over 40 hours. If the organization was audited and it was determined that yes, I did work over 40 hours in any particular work week, my base wage of $20 an hour now has an overtime of time and a half attached to it of $35 an hour, which means the company, as my employer, would owe me a second check. And penalties, state and federal, for not having complied with the wage and hour laws to begin with. So this 20 or 30% can be, in some instances, very appealing, but if you're audited, you're going to lose those savings, and you're on the radar now for a variety of organizations, state and federal, that have a strike against you and a reason to come back and check you again. And those audits, they're not pleasant. Think colonoscopy. Because they're invasive, they're time-consuming, they're uncomfortable, and they will cost you money, especially if they find violations. Now, the kicker is one organization or one aspect of the state or federal government, they can come in and they can audit you, and then what they're getting really good at is sharing information with other federal or state agencies. And then you have other agencies coming to say, hey, we want to take a look at your books. We want to take a look at this relationship. It often comes up in unemployment hearings where the individual, maybe he or she was an independent contractor, but they're required when they are claiming unemployment benefits to list all sources of income. And so if you have an independent contractor relationship, the amounts you've paid are coming up on their audit, their list. And the division will then turn to you and say, we see that you paid wages or monies to this individual. What was the relationship? And if you say independent contractor, then the division says, okay, prove it. Show us that this was indeed an independent contractor relationship. So again, that burden shifts onto your shoulders to make sure that you're in compliance with those requirements. Questions on the independent contractor, please.
So, paying a office space rent, would that have changed the situation now?
Good question. So let's tweak my example and now say, I have skin in the game. I have financial liability in that relationship because I am literally renting space as a business would.
Right.
And that means then a portion of the internet, the power, the space itself, all is on me. The employer is not providing that to me. This is a business-to-business transaction now with a contract that defines those terms. Yes, that would definitely change the relationship.
Okay.
Great question. Great example. Yes?
So if I sub out any type of work on a time and material basis, how do you separate visually the difference between the contractor and so I'm paying them hourly for the time and material?
So the example is I have a sub who I have handed a portion of my contractual work to complete because for whatever reason that is. It doesn't matter. Look at the best recommendation I can give in that instance is make it a business-to-business transaction. Show that there is an entity that you are contracting with, that there is a paper trail, that identifies the terms and conditions of that relationship, but also verify that they are indeed a business, that they're incorporated, that they advertise, that they hold themselves out to the community as doing whatever it is you have subbed off to them to accomplish. They have licensing, they're insured, they have those measurements or indicators of a legitimate business. Where you could run into risk is if you have somebody who says, I'm a sole proprietor, you pay him or her as an individual in their name, you pay them an hourly rate, you receive a time card, in essence, that shows what they've done. That's going to look like an like an employee. So you need to ensure that those relationships with your subs have those formalities in place. It's not right or wrong, it's just make sure that they have those formalities in place so that it looks and feels in all respects like a business-to-business transaction. Does that help?
Yes.
That was a very hesitant yes.
I'm thinking of like pipe welders. I'll get pipe welders to help me on bigger projects that are time and material, they're their own entity. But they're working under the direction of our foreman to do a portion of work on an hourly basis. In essence, they term an invoice that is a time card of the work they were directed to do, but yet I still consider that an independent contractor, but I guess they can be gray.
Okay, great question. So let me, just for the rest of the group, highlight that. So you have a pipe welder who is working under the direction of your employee, but this pipe welder is an independent contractor. He or she has his own business, insurance license, tools, all of that. But they're working under the direction of your employee. So is that enough to push us from an independent contractor into an employee situation? Maybe. And that's about as best as I can give you in this situation. Now, what we're looking at, though, is behavioral control. Who's in charge of that relationship? The financial control perhaps is you, maybe the organization, or maybe it's the independent contractor. What happens if he or she screws up? What happens?
Expect them to fix it
On whose dime?
on theirs.
Okay, so financial control, the risk of the relationship you've shifted to that individual, which is fair. Like if the plumber comes to my house and chips tile or damages something else, not my problem. That's you, independent contractor. You bear the financial risk or the gain of this relationship. So in that example, that's another factor that you would consider to hone in on who's in control, us or the independent contractor. Often I see it this way. We will reimburse the independent contractor for mileage. You reimburse employees for mileage, not independent contractor. The independent contractor, the cost of my doing business with you should be included in the bill you receive for my services. Not an itemized, and here's my mileage, and here's this, and here's that. This is what I'm charging you, period. That's the cost to do business with me, and I figured it out that includes my mileage, that includes my materials, that includes my licensing, and all that other stuff. Okay? So there's some questions that perhaps you may want to explore with counsel more carefully to have a close look at that relationship. Because again, think of that sliding scale. The fact that you have some behavioral control doesn't mean that slides us all the way to the employee side. That just means it's a notch. But if everything else says independent contractor, then you're probably okay. But it does merit looking at it carefully. Great question. Any others on that? Yes, please.
Similar situation, and when you're dealing with welders, if they're supplying their own equipment, if you're supplying the equipment,
That's a
you're
problem.
on shaky ground. So if you're supplying them the welding machine, all the consumables, everything, are they really a business or not? If that weld leaks, once you test it, if they have to fix that on their own time, then okay, independent contractor. If they fix that and send you a bill, they're potentially an employee. So it's shaky ground. You never know till that employee comes back or that person comes back and says, oh, now I want to be treated as an employee. You're going to pay all my taxes. I want unemployment.
Yeah. Now, in some instances, with the independent contractor question, you might find yourself in the uncomfortable middle ground where it may be more sensible to just treat and pay the individuals as employees, which means, of course, I-9, all the other terms and conditions of the employment relationship, hours worked, wage and hour, all that fun stuff, taxes and things, because it may make more sense to conservatively play that card instead of run the risk of being wrong and having the financial liability that comes with being wrong. Now, some companies, and I'm not saying I endorse this, but some companies take 3 sheets into the wind concern. I don't care. I've never been audited. I'm never going to get audited. I fly under the radar. People do that. I see it all the time. I'm not saying right or wrong, but it is the company's choice in terms of what their comfort level is with risk. What we've covered today is what the law requires and the outcome or consequences associated with being wrong and being audited. They're pretty severe. All right. Now, this one's a more complex topic. I could literally spend 8 hours on this next area. The fact that you have a physically demanding work environment. You have people lifting, bending, kneeling, squatting, pushing, pulling, carrying heavy stuff, working in the cold or the extremes. There's a lot of physical components to what plumbers and HVAC guys do, which means bodies wear out, bodies are injured, age factors into that sometimes too. What often and unfortunately happens is the businesses, the employers, they miss these issues, and then it's too late for them to address it without significant risk and liability. The key with this slide and this topic, is to be aware of it early on, and again, using the chess analogy, make sure the pieces and the procedures are in the right places so that you can successfully defend what may happen in the future. Now, we'll start. Oh, go ahead. You have a question.
So, you've got a person who isn't like physically in the greatest of shape.
Okay.
That's kind of their issue because they've not taken care of themselves on a personal level.
Okay.
But they're in a job that now affects their knees, their back. But we have to factor in their weight. You know what I'm saying?
I do. And I'll use that as an example as we talk through this.
Okay.
Let me set a little bit of a foundation first, and then we'll use your example
Okay.
to talk about the various areas here.
Okay.
So in the area of injured or ill employees, you have these 3 laws that must be considered in nearly every situation. Now, the FMLA, Family Medical Leave Act, or there's all sorts of acronyms, but the Friday Monday Leave Act and other ones. How many of you have 50 employees or more? By show, really, just needs. How many have 50 or more employees? Part-time, full-time, doesn't matter. 50 employees or more on the books. All right, the FMLA only applies to you guys. So if you're smaller than 50 employees, and again, that's full-time, part-time, doesn't matter. If they're on your books as an employee, counts towards the 50. If you're below the 50, everything we're going to talk about the FMLA does not apply to you. But if you're 50 or larger, the FMLA does apply. Okay?
And that takes effect as soon as you hire the 50.
No, there's once you hit 50, you have to be above 50 for at least 20 work weeks. Not consecutive work weeks, but just 20 work weeks in the current calendar year or the previous calendar year. So some organizations will cycle up and down. Anytime you hit over 50, that's a week. Count it as a week. And eventually, if it continues, you will hit 20. And when you hit that 20th week, now you are a covered employer under FMLA and are obligated to follow all of the aspects of the FMLA.
So you did back down.
Yes.
Okay. FMLA go away.
FMLA, when does it go away?
20 weeks.
So under the FMLA, in order to dip off of being required to comply with it, you have to have less than 50 employees. Actually, let me say it a different way. So think about that test again. 50 employees for 20 weeks within the current calendar year or the previous calendar year. So at some point, if you roll off of 20 or 50, let's say it's today. You're now below 50, March 28th, 2019. Your current calendar year, you're now off. Now we go to 2020. Did you have 50 or more employees in the current 2020 calendar year or in the 2019 calendar year for 20 or more weeks? If you can answer no to both of those questions, you are now no longer a covered employer for FMLA. So your look-back period is the current calendar year or the previous calendar year, making sure that you've not had 50 or more employees for 20 calendar weeks within the current or the previous calendar year. And if you can answer yes to that, then you're off. You're outside of FMLA. If you can't, you're still covered. Okay?
So 2 years after.
I was thinking
After you fall off.
2009.
So potentially it could be a 2-year look back. You're still on the hook potentially, but again, you need to do the math, do the calculation. All right, so FMLA, the key focus here, if it applies to you, is protected time off from work. Now, I'm not going to give really any more than that. Just understand that if I have an illness or an injury, whether it's work-related or because I haven't taken good care of myself, it does not matter. If it qualifies as a serious health condition under FMLA and you are a covered employer for FMLA purposes, you have to give me my benefits under the FMLA. And what generally that means is time away from work with full reinstatement rights when I come back. And we'll talk a little bit more about some of the pitfalls there. Now the ADA is designed to protect individuals with disabilities. Now, when we think of a disability, often the idea or the image comes into my head at least of someone in a wheelchair, someone on crutches, someone missing a limb. Well, the definition of a disability is much, much broader than that. It could be arthritis, it could be Alzheimer's, it could be PTSD, it could be anxiety, it could be depression, it could be missing a limb, it could be a bad back, it could be a bad back caused by obesity, it could be bad knees caused by obesity, it could be I just have crappy genes and I have a laundry list of issues. All of those conditions are disabilities. So for you in your workforce, you have to think about the individuals that we have and what medical conditions we are aware of. And once we become aware of a medical condition that limits the employee's ability to perform an essential function of the job, the ADA now applies. Now there is a threshold. You must have 15 employees or more for the ADA to apply, both state and federal. So if you're under 15, you can disregard this ADA component also. All right? Now the last one, which is the easiest, is the workers' compensation. Workers' compensation provides two simple benefits: medical treatment or meds, something because of an injury, and lost wages. So it's money and meds. That's it. Workers' compensation is not leave. It's not accommodation. Those are left to these other laws. Workers' comp is simply medicine, medical treatment, and lost wages. That's it. So this slide sets the stage for the common mistakes that employers make. Okay? Do we have questions initially about what each law covers? All right, silence means no? Okay. All right. So with the FMLA, again, this is for just the employers who have 50 or more employees. The first and most common instance of mistake that an employer makes is they fail to recognize when a medical condition or an illness or an injury qualifies as an FMLA protected serious health condition. If it's work comp related, it probably is FMLA too. It's probably ADA also. If I blow out my knee skiing and I now can't kneel, bend, squat, push, pull, whatever it is you have me doing, that's an FMLA condition, even though it was a recreational injury. Or if it's just because I'm too big or I haven't taken care of myself. Depending on what that condition, how it manifests itself, potentially is an FMLA serious health condition. The most common mistake that I see is the employer, the business, doesn't recognize the instance, the illness or the injury as an FMLA protected situation and therefore doesn't follow the law as required. and then something happens, a claim, a charge, or something, and the employee says, you know what? You forgot to do the FMLA, and I lost my job because of it. And now there's a whole host of penalties and consequences that the employer has to fix or pay for because of that. So the key mistake that employers make is failing to recognize when an illness or an injury triggers FMLA. That is simply an educational component for your managers and supervisors to know and understand and be trained to watch for. It's beyond what we'll cover today, but you just need to see it and recognize it as for what it is. Once we know that there's an individual who has an illness or an injury, we have a limited time frame to act. 5 business days to act and provide that individual with their FMLA rights and protections. The Department of Labor just issued last week an opinion letter, which is basically, under these facts, here's how we would interpret the law. And they said, if I, the employee, am eligible and have a condition that qualifies for FMLA, you violate the law if you're aware of it and you don't give me my protections. Even if the employee say, you know what, I don't want it, I can't waive it. So it's critical that you know and spot those issues. Another common mistake, tracking the FMLA time away. We have to very carefully document how much time the employee actually uses, because they're given 12 calendar weeks or work weeks to be gone on protected leave. And it's our responsibility to track and count that and make sure that if they need the full 12 weeks, that they get the full 12 weeks. What often happens is employers lose track or don't count, and you're left in some middle ground. If you've not given them their full benefits, there's a violation to be concerned about. Next, reinstating after leave. FMLA is protected leave with full reinstatement rights. Reinstatement means I come back to pretty much exactly the same job I had when I left on leave. That is my reinstatement right. So if I have a journeyman plumber, he's gone or she's gone for 12 work weeks, I hire a new journeyman plumber who's just fantastic, I still have to let that person go or move them out of that spot and bring back the person who is on leave and give them his or her job back, doing the same work, same terms and conditions that they had when they left. That's the reinstatement protections under the FMLA, and they are very, very broad. So again, in looking at that, a common mistake occurs because operationally, that doesn't make sense. I have a better person doing a better job. Why do I have to bump them out of that position? Well, because that's what the FMLA requires.
Okay, so at
Yes.
what point, if they can't come back,
Then you move into the ADA.
or to that level, okay, then it's the
Yep, if I can't come back under FMLA, okay, now we've moved the FMLA out of consideration. Now we have to talk about the ADA and an accommodation, what that looks like.
Okay.
And maybe additional time would be a reasonable accommodation, which leads me to the next slide. So, failure to comply with the ADA, same starting point. We don't recognize when an injury or an illness or a physical limitation that impacts the performance of the job qualifies as a disability. That's on us to be aware of. Now, under the ADA, the employee, if they want to invoke the rights and protections of the ADA, they must let us know that, hey, I've got a condition and I can't do my job because of this condition. Now that is true unless the condition that they have is open and obvious, or if we already know about it. If we already know about it and we discipline them for not doing their job, and I'll use your example, I have, I don't know, arthritic knees because I'm heavy, I'm a big dude. And, pardon?
No, you're not.
Well, hypothetically, I have arthritic knees, I can't bend, I can't kneel, and I come to you and say, yep, I can't crawl through the ditches anymore, I can't do this, that, or the other, and those are all critical, essential functions of my job. I basically told you I'm disabled and I need an accommodation. And now we have to go into the ADA process. That doesn't mean we just let him do whatever he wants, but it's the formality of the discussion that has to occur and the analysis that we're required to demonstrate that we've done. Okay? All right, so common mistake number 1. Next, once we have an individual who's disabled, and again, I'll use the example, I have arthritic knees, I can't kneel down in confined spaces, or I can't kneel period, and that's why I'm not meeting my performance expectations. That's a request for an accommodation. That's a request to initiate the interactive discussion. If we don't take that and have that conversation, that's a mistake on our part which can trigger liability because we're obligated to have that conversation. Next, failing to provide... I'm sorry, what? Go ahead.
Just a comment, right?
Sure, please.
Sometimes you have the conversation that you don't document. It can be verbal. It needs to be documented sometimes.
So, can we have a conversation that is verbal with no documentation? There is generally not a law that will penalize you for that. You don't have to write stuff down in most instances. However, the question is, and think of the chess analogy again, if I want to demonstrate that we complied with the ADA interactive process, that we had a conversation, that you disclosed what was the issue, that we worked through it, that we provided something, that we talked and conversed and interacted. If you want to conclusively demonstrate that that happened, your verbal assertion that it did is not enough. You need paper. You need a process. And you need to be able to produce that to show that you have indeed met the obligations the law imposes on you.
Require a signature from the employee.
Maybe. Should the employee sign it? Maybe, maybe not. And there's a variety of ways you can do that. Could you have a conversation and you then send an email that says, here's what we talked about. If you disagree with any of this, or if you have any additional comments, please reply. If not, I'm just going to set this in the file. That would be good enough for me, especially if the employee didn't respond. And assuming, of course, that they received the email. But yeah, a signature works. It's not a contractual binding. It's just an acknowledgement that we had the conversation. That's really all that you're looking for. And that can take a variety of different shapes. Great question. Great question. All right, the last one is, again, common mistake, and this is both FMLA and ADA, is we don't protect the individual with the disability or the FMLA condition from retaliation by coworkers or others. Because, for example, I take 12 work weeks off. My coworkers have to pick up the slack, and that sucks. I come back, I get my job back, everything looks like it never happened, and they might be irritated, upset, angry towards me, and that's a human, natural response. The problem is when that response manifests itself as treatment directed towards me for using a protected right that the law gives me. That's retaliation. So when you permit coworkers to harass, to belittle, to humiliate, to modify the terms and conditions of the employment relationship because I'm upset that you got time off, that's retaliation, and those claims are extremely easy to prove. So you have to watch that. Be careful and be aware. All right, what time? Oh, go ahead and somebody tell me what time it is. 12 o'clock? All right, go ahead.
So you hypothetically have somebody in your company that falls underneath this ADA or the FMLA.
Okay.
They're out for a period of time. They come back to work. Business slows down. You have to downsize, and they're one of the ones that left. Is there any problem with that? Do they have to be there for a certain period of time before that happens?
Great example. In both instances, actually, let me repeat the question. So we have someone who uses protected rights under ADA or FMLA. They come back, everything's hunky-dory. We have a downturn due to economics or loss of a contract, and now we have to lay people off. Is there a time frame that we should be concerned about if this person who just used ADA or FMLA rights is included in the layoff? Maybe. Now, retaliation protects me from being under the ADA discriminated because I used the ADA, or under the FMLA for taking the time off. So if you're laying me off because I used ADA or FMLA, then that's illegal. That is retaliation. However, if you have a legitimate business reason for why I'm included in the category of layoff, and it's indeed a legitimate business reason, not a fabricated business reason, then you can successfully defend that as unrelated to the protected leave or the protections under the ADA, and that's not discrimination. But again, therein is your obligation. It's your burden to demonstrate the legitimate business reason, whatever that is. And that's where, again, to your point, paper becomes critical, showing not only what the issue is, how we work through it, and then ultimately how we decide who stays and who goes. If there is indeed a legitimate process that concludes, well, this was the last person hired, or the lowest skilled, or the person with the poorest performance, all of those would be legitimate reasons to justify why I let the FMLA person or the ADA person go. But that's on us to demonstrate indeed that those reasons exist if you're challenged. Great question. All right. In the interest of time, I think I'm going to skip over some of this and move to, if you want to take a picture. If you guys want, I'm happy to send you the slides in a PDF form if you want. Just send me an email. I'll put my email address back up, and you can send an email request, and I'll just PDF these to you.
Quick question on the ADA.
Yes.
Is that part of the 50 or more employees?
No, it's 15 or more employees. 15 or more. And that here in the state of Utah is something that you want to watch carefully each legislative session. They had a bill, it didn't make it through this year, but would have dropped that number down to 5. So 5 employees for state ADA protections would become the new law. It didn't pass, but it's 2 years in a row that they've had that, so I anticipate that next year watch it again. All right, I want to focus on this next slide. Employers screw this up all the time, and this is not industry specific. It is not employer specific. This is just we mess this up all the time. So here are some examples of commonly provided accommodations to individuals with disabilities. Now, as you look over this list, can you identify one or two or some that may not be required by the ADA? Is there anything or one of these that stands out and you think, I'm not feeling that one? What do you think? Let's start with that one. Where is that one? Top right. Waive warranted discipline. All right. So your performance is crappy. I discipline you for crappy performance. And after the conversation or during the disciplinary conversation, you say, oh yeah, by the way, the reason why I'm unable to do my job is because I have fill-in-the-blank medical condition. Are you at that point, and that statement is basically telling you I have a disability, and I'm asking for a reasonable accommodation, and this is the trigger for the interactive discussion, are you obligated to take that discipline and say, nope, never mind? No. If indeed this is the first time you've heard about the medical instance, then no, you're not required to waive discipline that was merited based on poor performance. But from that point moving forward, now you're under the umbrella of the ADA. Now you have to go through the interactive process. Now you have to provide reasonable accommodations. Anything else?
Do they have to prove, do they have to provide something that says, I have been diagnosed?
I'm disabled.
I'm disabled.
Great question. What level of proof is the employee required to provide when they trigger the ADA by saying, I have a disability? Well, your response then is, okay, here's a form, and this is a form that we provide to our members. It's a medical inquiry form. But this form, you need to take to your doctor because I trust you, but I'm going to verify. And your doctor has to complete this. It has to come back, and then we compare it to what the ADA says is a disability. And then if it is, we look to, okay, what should we provide? What are the essential functions that you can't perform? And what reasonable accommodation should we then give you to enable you to do your job? That's the key outcome here, is I have a disability, and I can't do my job or some function of my job. Our obligation as the employer is to build a bridge between the two and enable them to do the job. That's what we pay them for. Right. Yes. Oh, go ahead.
Sorry, are they required to, when they come in for an interview, to disclose it?
Ooh, good question. So, hiring stage, I am an applicant now. Do I have any obligation to tell you I am disabled? Nope. Can you ask if I'm disabled? Nope. Can you ask if I'm qualified to perform the essential functions of the job with or without an accommodation? Yes. So your questions in an interview center around can you or can you not do the job, not are you or are you not disabled. The same as I wouldn't ask, so tell me your nationality. Tell me what your last name, do you have a family, do you have kids, are you married? I'm not going to ask those questions. My focus is on can you do the job, period. And the ADA provides protections in the application phase where you can't ask those questions, nor am I required to disclose. You had a question?
All right, so on the way to work this week, so we had an individual past of where wasn't showing up for work, wasn't letting us know. I brought him in, questioned the heck out of him, said what the heck's going on. We made a deal, he couldn't show up for work on time. Next week, then I brought him back and said, all right, you gotta really know what's going on. He said, oh, I had anxiety attack last night, I was in the hospital. I said, okay, do you have any stuff from the doctor? No, I didn't actually get checked, I just met with the doctor. So I gave him 2 days off, said, he told me he needed to go see his therapist. I said, okay, go see your therapist, bring the paperwork back. Never provided anything.
Okay.
He's told me he has something, he won't give me any verification. I asked for further stuff, he hasn't quit.
Okay.
So scenario, and this happens all the time, the employee triggers triggers the protections of the law by claiming a disability or saying, in this instance, I have an anxiety attack, went to the hospital. They trigger that, and our response then is, okay, trust but verify. And we verify with medical information from the healthcare provider to justify what you're telling me, and then based on that medical information, we make decisions. If I've asked for and the employee fails to provide the medical information, the trust and verify relationship is now broken. They've not verified, and I don't have to rely on an assertion alone unless there's other information like a paper, a file full of documentation that would say, yeah, I have anxiety. But if it's a clean file, there's no prior history, the employee is obligated to justify with medical support that they have the condition they're claiming. If they fail to do that, they fail to participate in the interactive process, which in effect kicks them outside of the protections of the ADA and leaves them exposed to the full weight of whatever those consequences are. Okay? Go ahead, and then yours.
Okay. Let him go first and then.
Okay.
So you said reasonable accommodations. Who defines what's reasonable?
Oh, great question. Great questions. Let me, and I'll come to yours. So, what is a reasonable accommodation? Well, the law says, and there's not a list, the law just says, employer, your obligation is to determine an accommodation or to provide an accommodation that enables performance of the essential functions. So it depends what the employee can't do. Your obligation is to provide something that enables performance. Now, there are some things that you're not required to do. You don't have to create another job, or I don't have to hire somebody to do your job. Again, my obligation as the employer is to give you something that will enable you to meet the functions of the position, the same as anyone else is required to do. But I'm not required to hire someone new or create a new position. I'm not required to take away those essential function requirements. So if I have to lift 50 pounds repeatedly throughout the day because that's an essential function of the job, and I have a bad back and I can't physically lift it, I'm not required to take away that lifting function. I'm obligated to see if there's something we can do that will enable you to lift. And maybe it's time. Maybe I can't. And if I can't, then the ADA moves us into a different area. But I'm not required to lower that performance expectation.
And you don't have to go and buy something that helps them lift.
Not necessarily. Not necessarily. Now, if, and there's a whole bag of questions in that example, but if, and let's put it in a manufacturing or production facility, so I'm not out on the floor, I'm not out on job sites, would it make sense to have a lift to move product from the ground to the working table where I can then do everything you need me to do? I just can't pick up the box from here and drop it here. Would it make sense, and could the ADA require that you purchase some kind of a lift? Perhaps. Perhaps.
Okay.
So the ADA in many instances does require the expenditure of money.
Okay.
Now, how we can get around that is a more complicated question, and we're not going to cover that today because that's like a 2-hour discussion. But yes, generally, you might be able to be required for that. Last, we talked about the discipline. This one here is, I'm not required to remove or take away essential job functions. What defines an essential job function? You. You do as the business. And you should have a job description that says this is your essential function or functions. Okay? Did that answer your question, or did you want to touch on something else?
It was kind of on the interview process, you're someone applying. You can't ask those questions, but if they volunteer that information, you can record that and keep it as part of your record.
Good question. Let me answer that with an example. This was a case. Company interview, in an interview situation, 3 men and a pregnant woman comes in for the interview. She is visibly pregnant, okay? And 2 of them commented on their documentation, pregnant woman. So on their interview list, their question and answer sheets, they wrote down pregnant. She didn't get the job. Why do you think she claimed that she didn't? Because she was pregnant. And what was the proof that they allowed pregnancy to factor in and influence their decision? That they wrote it down. So if you observe or the applicant discloses protected characteristics, no, don't write them down. If I bring it up, yeah, I'm disabled, I've got this crappy back condition, your response is, okay, well, we don't consider disability when we make hiring decisions. The question I want you to answer is this: can you perform the essential functions of the position with or without an accommodation? Question mark. That's the only thing I care about. And if the applicant says yes, that's good enough for me at that point. Now, could you have at some later stage a fitness for duty exam where you verify their physical ability to perform that? Sure. But in that initial interview stage, that's as far as you can go.
So don't record it then, is what you're saying?
I would not, because if they don't get the job, that's Exhibit A that I put up in front of the jury. That you noted it, you wrote it down, and therefore, how did it not influence your decision to not offer me the job?
Even like if they say I've got 3 kids, don't write down I've got 3 kids.
It's not technically in Utah a protected characteristic, but it could be under expressive activity that's protected. So yeah, job related, I guess we should probably have that as a slide. Keep it job related. You care if they can or cannot do the job. That is the only question you're trying to answer in an interview. Not whether I like them for whatever reason. All right. How are we doing on time? You said 12:30. It's a little bit of gray there, Dave. Give me a...
Just know that we're
Can I go till 12:30? 5? Okay, 12:20. Okay. All right, harassment. It happens. Me Too movement has made this much, much more prevalent, and employees are much, much more empowered and likely to bring it up. So when we're talking about harassment, the key for you to recognize and understand is your obligation is to first prevent harassment in the workplace. If it comes up, you are obligated to correct it in a prompt and appropriate manner. Now, what that looks like, we'll talk a little bit this afternoon in the handbook session. I think it's at 4 o'clock, I think marijuana is at 3 and handbook's at 4. We'll talk a little bit more about what this looks like at the 4 o'clock session, but just know that it's your obligation to prevent and promptly correct. You do that in a variety of ways. A handbook policy is one example, a complaint mechanism that actually works, investigations perhaps if required. All of those are ways in which we promptly prevent and correct harassment in the workplace. Inadequate documentation, we've covered this a little bit already. It's a key issue because, again, if I'm an independent investigator who's listening to an employee or a former employee say, this is what happened in the workplace, and I come to you, the employer, and you contradict that, now I have a question of, well, who do I believe more? The complainant or the employer? Documentation is what gives you the benefit of the doubt. It's what pushes you over the edge. So you look at documentation from a very simple perspective. What are the facts? What are the objectives or the goals that we were trying to accomplish, whatever that may be? Suggestions as to how the employee can improve, and actions taken. Now, that's like an entire documentation class in 30 seconds, but write stuff down. But be careful about what you write down. Make sure that it, again, relates to the job, the functions performed, the consequences, why it matters, the harm perhaps that the organization sustained. Do not put in emotion or supposition or assumptions. Stick to what you know and the harm that's caused and what the consequence or the outcome is. Very simple remedy. All right. Improperly paying employees, there's two parts to this. For those who are non-exempt, meaning hourly, you have very fundamental wage and hour requirements. Pay them for every hour they've worked or portion of hour, and when they cross over 40 hours in a work week, pay them overtime at a time and a half rate. That is your obligation under the wage and hour laws, state and federal. Mistakes in this occur all the time. Mostly they are unintentional or they're mistakes, but it's on you. If you find them, fix them. If the employee comes to you and says, hey, I don't think you paid me properly, investigate and make sure that you did, because this is a significant risk. If you are found to have not paid proper wages, the auditing agency can take a look back 2 years in time. Think about that. 2-year look back. And if I find violations at any point in those 2 years, you're on the hook for that. Of course you'll pay the wages, of course you'll pay the overtime, but you also pay what we call liquidated damages, which is basically double the amount. And I'll give you an example. A restaurant, $50,000 in unpaid wages, they were found liable for. They didn't pay it. So they had to pay the wages. Then the agency turned around and said, oh, by the way, here's liquidated damages. That's another $50,000 on top of that. Thank you for playing. So you've got to be very, very attentive of that. Last issue with exempt employees, these are your salaried employees who, based on the functions they perform and the amount you pay them on a salary basis, we don't have to track hours. We don't care how much they work or how little they work. It doesn't matter. They earn the same amount. This is a 3-part test for exemptions. Note that there is currently a change pending for the amount of salary, this minimum required amount. Currently it's like $455 per week or about $24,500 a year. That is going to change to about $36,000 per year. So to have an exempt employee, that minimum salary amount goes up if these regulations pass. In addition to making sure that you pay them on a weekly salary basis, you're not deducting for poor work or missed time, and they perform certain exempt duties. Longer discussion, but just something to be aware of to trigger additional questions. All right, at-will terminations, I'm going to end on this. I hear all the time employers say, but this is an at-will state. I don't have to have a reason why I terminated your employment. That is technically correct. You do not have to have a reason to terminate in an at-will employment state. I could say, I don't like your socks, or you wear crappy jeans, or your hair looks funny. That even might be a little shady.
You don't even have to give a reason.
I don't even have to give a reason. Now, here's the kicker though. The absence of a reason will cause the employee to do what?
File a complaint.
Why? Why was I terminated? Oh, I just happened to be the only African American guy on the crew, or the only Hispanic, or the only pregnant woman. If you say or utilize an at-will termination, I'm not going to tell you why I'm letting you go, it's just not working out. You allow the employee to then frame the narrative and conclude whatever it is they want to conclude, and perhaps trigger a complaint. You don't want a complaint. Control this from the outset. Here's what often happens. At-will termination, I didn't give you a reason, I just don't like you, thank you. And the employee says, you know what, I think there's more to this. And I'm going to file a claim. Claim comes back to the employer. Inevitably, the employer says, oh, this was a terrible employee, crappy performance. And my first question is, well, why didn't you make that the reason for the termination? Because now you're inconsistent. Now you've said, oh, I just at will, don't need a reason. But now you're saying you were a terrible employee. That inconsistency is a weakness in your credibility. And that loss of credibility may cause you the case. So when you think about at-will terminations, it's not ideal. You give the employee, like you said, the ability to fill in the blanks as to why you did the termination. And that's not where you want to be. So here's my information. This is my social media platform. If you like, subscribe, and write this down or take a picture, and then I'll go back to the email or the slide with my email address on it so you can see that.
Do you do more training, like more extensive?
All of this we have a variety of content on.
In Salt Lake?
Yeah, in our Salt Lake office. But we've started. Yeah, Spears Plumbing is one of our member companies. We've done a lot of work with them. Like I said, we're a membership association. Companies join as a member, and in exchange, we provide a variety of benefits: legal advice, legal representation, audits, like Jared mentioned. There's a variety of resources that we provide. I think it's well worth your investment. And if you want to have a conversation, the table's right over there. Let me get to my email address. If you want to know more, please send an email. We'll get there, we'll get there, we'll get there. There it is. Send me an email if you'd like to talk more. We do trainings all over the state. Doesn't matter where you are, we'll work with whoever. All right, thank you.